It has no other basic information or navigation features as to what a regular website ought to contain as a contact, about, etc. The author of the content of the website revealing the information on INEC server claimed to be an INEC staff. He remained anonymous and hence Christian whistleblower. In paragraph 18 and 19 of his witness statement of oath, he concluded as follows: bearing a simplified and common understanding of the server and quotation and a computer, a device or a program that is dedicated. I'll take that again. A, bearing a simplified and common understanding of a server or a computer is a device or a program that is dedicated to managing networks, resources, such as storage, communication, security, centralized applications, and database management system, and acknowledging the INEC guidelines which outline a transparent and integrated electronic process of voters' accreditation, vote collation, and transmission. Indeed, there existed a robust system of servers whose extensive use in the presidential election is undeniable. B, the analysis of data held at the whistleblower website using standard professional data analysis tools and techniques authoritatively demonstrates accuracy and precision, legitimacy and validity, reliability and consistency, timeliness and relevance, completeness and comprehensiveness, granularity and uniqueness of the database, of the data whose base can be nothing but INEC servers. C, an expertise, corroboration, and correlation of the technical processes, data, and description of whistleblower data hearing and the INEC setup is an explicit and implicit demonstration that the server from whose data the whistleblower was drawn is INEC tallying server. 19, that a report in my findings are attached and marked as Exhibit 8. Its evidence is that it is the whistleblower's data analysis, facts don't lie, website, www.factsdon'tlieng.com, that his report is based on. He variously referred to the owner of the website as a whistleblower, as anonymous, or the author of the content of the website claimed to be an INEC staff. PW59, as could be seen in his evidence, did not rely on any data gotten by him from INEC server. He stated that the server he relied upon for his report as an expert was an anonymous website, which to me is doubtful, unreliable, on any account, for any information that would be relied on by an expert who is truly an expert. PW59 gave his evidence and report, and the report he authored. Whatever results he claimed to have gotten, according to him, came from the server belonging to a whistleblower and not INEC. When asked under cross-examination the source of the results he claimed were found in the anonymous website, PW59 said the author of the content of the website may be an INEC staff, but that the anonymous author of the content of the website got the information or the result from INEC servers, which he said he could not access without the consent of INEC. Under further cross-examination, he admitted that the information in the website whistleblowers data analysis facts don't lie website, www.factsdon'tlieng.com, could have been doctored. Under further cross-examination by the line senior counsel for the third respondent, PW59 said, as an expert, it is possible to use scientific method to decrypt data source and tamper or alter the content or information contained therein. PW59's report and evidence is thus hanging on the third-party information from an undisclosed source. The evidence of PW59 is no doubt caught by Section 37 of the Evidence Act, which provides, and I quote, "Hearsay means a statement, oral or written made otherwise than by a witness in the proceedings, or B, contained or recorded in a book or a document or any record whatever, proof of which is not admissible under any provision of this Act, which is tendered in evidence for the purpose of proving the truth of the matter stated therein." I underline some portions. End of quote. As can be seen from the evidence of PW59, you cannot, by any stretch of imagination, be classified as an expert opinion, as it is not supported by any direct knowledge of what his report contained. It is with regard contained, and it is not supported by anything he did directly with regard to the existence or otherwise of an INEC server, which he now claimed to have gotten the information from. He relied on the third-party information drawn or prepared or given to him or through the whistleblower, an anonymous source, an incredible and unverifiable source, which is not derived from his own personal knowledge. Worse still, his informant, the author of the content of the website relied upon by him, cannot be identified. Even if it could be identified, it is the alleged whistleblower or the anonymous author who claimed to be INEC staff or who was a former INEC staff that could give evidence of anything relating to the existence of the alleged server, from which he got the information, which he now put up in the website www.factsdon'tlieng.com, on which the petitioners heavily relied as containing results of the election electronically submitted via the smart card reader. PW59's evidence is very unreliable because it is hearsay and it is inadmissible. In Saraki and Neferang, Federal Republic of Nigeria, a case decided in 2018, Weze, JSC, said, "Now, it is well known, hearsay evidence, oral or documentary, is inadmissible and lacks probative value." Section 37 and 38 of the Evidence Act 2011, Ozude and Inspector General of Police, 1965, 1 All Nigeria Law Reports, 102, Okoro and the State, 1998, LPELR 2493 SC 17, 1998, 14 NWLR, Part 584, at page 181, Buhari and Obasanjo, 2005, 13, Nigeria Wiki Law Report, Part 941, at page 1, particularly at page 317, DOMA and INEC, 2012, All Federation Weekly Law Report, Part 628, at pages 813, particularly at page 829. 2012, 13 NWLR, Part 1317, at page 297. Okpara and Federal Republic of Nigeria, 1977, NSCC 166. Management Enterprises and Otusonya, 1987, NSCC 577. 1987, 2 NWLR, Part 55, 179, Ojukwu and Oudue, 1984, 1 SCNLR 247. End of quote. I also made reference to some other cases in respect of the position. PW 59 also went out of his way to interpret INEC's manual in providing the INEC's manual providing for electronic transmission of results of the 2019 general election. They said the witness is not competent to interpret election manuals which were admitted and tendered and admitted in this court as an exhibit. It is within the province and domain of this court to give interpretation to the election manuals and regulation of INEC, which I have done above. In effect, the evidence of PW3, PW4, PW16, PW17, PW36, and PW59, together with the expert report in XBP 91, cannot be relied upon to come to the conclusion that there was indeed, in fact, there was INEC server or servers, as the case may be, wherein results are transmitted electronically from the smart card readers in the 2019 presidential election. The pieces of evidence given by those witnesses lack the probative value to prove such an allegation. Now, the evidence of PW60. The petitioners have also relied and regarded the evidence of PW60 as evidence of an expert to establish the anomalies or irregularities they pleaded in the core 11 forecast states earlier listed in this judgment, and constructed, in respect of which they constructed various tables to show the loss of the vote loss and vote gains by the petitioners and the second respondent, and came to the conclusion that if the errors committed by INEC officials are done away with, the petitioners will be leading by 222,332 votes. I think a proper appreciation of what the petitioners have done in the tables aforesaid, it will not be out of place to set out the submissions of facts by the learned senior counsel for the petitioners in the final address from paragraph 4.46 through to paragraph 5 to paragraph 4.52, which are as follows, and I set them out. This table, constructed in the learned senior counsel address, was lifted from the exhibit attached to the witness on oath of PW60. A calm perusal and examination of the exhibit attached, XBP K90 to 90AK, shows a conglomerate examination of the Form EC8A from polling units with observation by him which polling units results were signed or not signed, which one shows bad votes or mutilated results, and sundry other criminal allegations of malpractices or irregularities. It is a strange attempt by the petitioners to use PW60 as a witness testifying in respect of all anomalies or evidence of crime allegedly committed at the polling units and doctrine of results by unnamed persons. No witnesses were called to establish all the allegations made against the results of the election in the polling units or the local government level. Witness number 60, PW60, testified that he used duplicate copies, that the pink copies of Form EC8As to carry out his job, and he utilized Form EC8As, EC8Bs, and EC8C series. Under cross-examination, however, he recoiled and stated that he, in fact, used certified copies of Form EC8As. He did not know what Form EC8C is. All the things he did in Exhibit P90 A to K ended up in what he called an executive summary on the findings on votes recorded in certified 2 copies of Form EC8As for the 11 focus states. He failed to demonstrate to this court how he came about the conclusion reached by him, and upon which the petitioner's learned senior counsel raised the table which I've set out above. It is my decision that PW60 cannot be regarded as an expert under any guise. As a matter of fact, he admitted under cross-examination that he was not certified by any institution. His evidence, like the evidence of PW59, lacks any probative value or worth, and the pieces of evidence he gave are not worthy of any weight to be accorded them in this petition. Consequently, I hold that the petitioners did not prove any of the complaints laid out in respect of the 11 focus states, just as they failed to prove the facts in paragraph 106 of the petition, result of which they claim was derived from votes in the server imputed through smart card readers. Again, the tables injected or constructed in the final address of the learned senior counsel for the petitioners are not covered by any of the pleadings of the petitioners contained in paragraphs 16 to 106 of the petition in relation to issue 3 under consideration. The law needs no restatement because it is now tried that parties are bound by their pleadings, and any evidence laid which is at variance with averments and pleadings of the parties go to no issue and will be discountenanced by the court. Made reference to a few cases on the position. It also follows that the brilliant address of the learned counsel cannot take the place of pleadings or evidence which ought to be led through witnesses conversant with the facts in issue. The aforesaid tables computing votes ascribed to the petitioners and the respondent, the second respondent, as representing correct votes by the parties cannot be countenanced because they lack any probative worth. The courts do not accord or allocate votes to parties in an election petition or on arbitrary evidence that has no support in pleadings and evidence adduced before it. I refer to a statement by His Lordship IT Muhammad JSC, now CJN, in the case of INEC, Silver and INEC, which I've set out before now, wherein he said, "It is clear from this piece of evidence that the appellants did not themselves know the number of votes alleged by them to have been cancelled by the first respondent. It is known to all that a court of law is not a magician who will begin to allocate votes or to reduce votes arbitrarily. It relies and makes its decision upon tested evidence placed before it. So the appellants have failed to lead evidence as to the actual number of votes alleged to be cancelled at the Bayelsa state government election held on 5th and 6th of December 2015 and on January 9th, 2016. Their claim as pleaded goes to no issue at all. And further, the case of Oti and Ekwazi Supra relied on by the appellant is not helpful to them, as it is quite distinguishable from the present appeal." End of quote. Another point, important point to recall, is that the relief sought in ground 15A is that it may be determined that the second respondent was not duly elected by a majority of lawful votes cast at the election. It has been acknowledged by the parties that it is a declaratory relief, and the law places heavy burden on the petitioners to prove the relief or their entitlement to it on the merit. contained in the paragraph contain imputation of crimes also in the electoral processes against the second respondents, against the first respondent and their officials/agents. Some of the allegations are as follows. 1. Inflation and deflation of votes. Alteration of figures and votes cast in favor of the petitioners. Overvoting. That the first respondent wrongly credited petitioners. That the first respondent wrongly and unlawfully credited the second respondent with votes which were not valid or lawful. Polling units. Wards, collation centers, and state collation centers. That the first respondent's official did not correctly collect votes from polling units in Abia, Adamawa, Akwa Ibom, Anambra, Bauchi, Bayelsa, Benue, Borno, Cross River, Delta, Ebonyi, Edo, Ikiti, Enugu, FCT Abuja, Gombe, Imo, Jigawa, Kaduna, Kebbi, Kogi, Kwara, Lagos, Nasarawa, Niger, Ogun, Osun, Ondo, Oyo, Plateau, Rivers, Sokoto, Taraba, Yobe, and Zamfara states. The petitioners did not call any witness in respect of all these sundry allegations made in respect of each of these states to give evidence of wrongdoings and/or crimes allegedly committed in the presidential election conducted in the said state. Apart from the fact that the allegation must be proved beyond reasonable doubt because it is criminal in nature, it is also incumbent on the petitioners to call evidence polling unit by polling unit in order to establish all the accusations, irregularities, and gross misconduct alleged against INEC officials, the second and third respondent, and other persons. That is the requirement of the law. In Yesom and Peterside, Declaratory has stated that the purport of the appellant submission in respect of the evaluation of evidence by the tribunal, which was affirmed by the lower court, is that the tribunal and the lower court applied the decision of this court in Kaki and PDP and Ucha and Elechi Supra. They would have reached a different conclusion. It is significant to note that there are 23 local government areas in Rivers State. According to Pt.3, a state collation agent, there are 4,442 polling units and 1,350 voting points in the state, making a total of 5,000 voting points. Some allegations made by the first and second respondents include Roman 1, non-voting due to violence, thuggery, and intimidation of voters. 2, snatching of election materials, non-use of card readers. 3, non-collation of results at ward level at ward collation centers. 4, arbitrary collation of figures. Arbitrary allocation of figures. 5, non-provision of Form EC8A. 6, result sheets not showing results of all political parties that contested the election. 7, in order to prove the alleged acts of non-compliance, it is necessary for the petitioners to call witnesses from all the affected polling units to give first-hand testimony of what transpired. Out of the 56 witnesses called by the first and second respondent, 18 were ward collation agents who received information from polling agents in their various units. Their evidence was not tied to any of the exhibit standards. Some of the witnesses, PW 19, 20, 24, and 35, who were local government collation agents for the second respondent, gave sweeping testimony covering 4 local governments on non-use of card readers, hijacking of materials, illegal trumprinting of ballot papers, etc. The polling agents from the affected wards were not called to testify. The tribunal made special reference with testimonies of these witnesses, and the evidence of Pw.49 has been dealt with extensively earlier. I am inclined to agree with the learned senior counsel for the appellant that the evidence of Pw.40 cannot take the place of polling agents or voters who were disenfranchised. Again, in the case of Gundiri and Nyako, decided in 2014, Ogumbi JSC, still on the significance of evidence of polling agents, had this to say: the significance of polling agents cannot therefore be underestimated in the case at hand if the appellant must prove the facts, if the appellant must have the facts to prove their case. The best evidence of the appellants could have had was that the agents at the polling units who were physically on the ground and in true position to testify as to what transpired at the election. The consequence of shutting them out for whatever reason is very detrimental to the appellant's case. See the case of Hashidu and Goje, 2003, 15 NWLR, Part 843, 352, and Buhari and Obasanjo, 2005, All Federation Weekly Law Report, Part 273, page 1 at 164 to 165. 2005, 13, NWLR, Part 941 at page 1, particularly at page 4, 248, paragraphs B, C, where a Juwumi JSC said, among others, the evidence required to establish a crime must be evidence of a witness who saw or heard or took part in the transaction upon which was given evidence. It is written law that hearsay evidence is not admissible for the purpose of establishing a crime. See Section 77 of the Evidence Act, end of quote. On the fatal effect of failing to call a polling agent, the case at Agbala and Chime, 2009, 1 NWLR, Part 1122, 373, at 433 to 434 is relevant, where it was held thus: none of the appellant's party agents that allegedly represented the appellant had signed or collected the results of the election form from the numerous polling booths and were called to testify in this petition. A fortiori, the failure of the appellant to call party agents that represented and serve as representative at the various polling units to give evidence was fatal to the petition. I also made some reference to some other cases. Because there's no eyewitness account and no evidence was called by the petitioners to prove the scathing allegations of misconduct, electoral misconduct, which are in the nature of allegations of a crime, there's nothing that this court can base its decision in respect of such sundry allegations. What is more, the petitioners tendered all the Form EC-80s, like I said, EC-8Bs, EC-8Cs, EC-8E, and Form EC-40G, and other relevant forms used by ANEC for the recording of votes and declaration of the report of the result, the subject matter of the complaints in paragraph 16 to 106 of the petition. However, I have mentioned, and I will repeat it, that the petitioners failed to call the makers or their agents who were signatories to the documents and who did not sign or sign but are agents of the petitioner to testify concerning the irregularities and allegations made against the respondent. The petitioners, in effect, dumped these exhibits on this court, dumped their exhibits on this all-important issue or unlawfulness of votes on the court without calling their makers or those with knowledge of the documents to testify. This court cannot, therefore, in law, accord any probative value to the exhibits. It is the duty of the petitioners to tie their documents and exhibits to the aspect of their case and to lead their witnesses to demonstrate the application of the votes explained in their pleadings and the other evidence of alteration, inflation, or deflation of votes, raking up figures in favor of the parties by the electoral officers or other persons. In the case of Ekwezu and Oti, 2016, Galadima again said, it is settled law that a party who did not make a document is not competent to give evidence on it. I also refer to the case of Ladoja and Ajimobi, case of Emmanuel and Umana, which I also referred to earlier on. The learned senior counsel for the petitioners has submitted that they have established the position, that the established position in this and many other cases has changed, and that the party is no longer required to tie or link documents in evidence to specific areas of his case to the documents it relates. He cited and relied with some relish on the case of MTN and Corporate Communication Investment Limited, which was decided this year, and citation of which is set out. The case is also reported in 2019 6 Supreme Court Monthly at page 100 for the submission. However, the facts of the case the documentary and other pieces of evidence involved in the case are, however, distinguishable from the facts in this case. The facts in that case involve a contract between the parties, and the document in question was the written contract, which was admitted at the trial court as Exhibit A. Exhibit A was admittedly the binding agreement between the parties, and the appellant before the Supreme Court used it as the basis for the termination of the contract by issuing Exhibit B in the case. At the trial, the respondent's witness had given evidence on the terms of Exhibit A, and he was cross-examined by the appellant's counsel. On the arguments before it by the appellant's counsel that Exhibit A in the case was not demonstrated, Kekere Ekun, speaking for the Apex Court, JSC, stated earlier that it is therefore not correct to contend that the terms of Exhibit A were not demonstrated before the court. The salient point to be noted in this case is that Exhibit A in question was an agreement between the parties, the terms of which were not in dispute, but expressly admitted by them. On the contrary, the contents of the documents tendered by the petitioners from the bar are and have been frontally, directly, and specifically disputed in the pleadings of the parties, such that proof, as required by law, becomes absolutely necessary if the documents were to be used and relied on in the determination of the petition. The allegation in respect of which the documents were put in evidence as contained in the paragraphs of the petition are varied, they are distinct, they are different and diverse in context, in character and nature, for each of them to require specific link or connection to the evidence of the witnesses who testified in respect thereof. The facts and circumstances of the case of MTN and Corporate Communication Investment Limited Supra are therefore clearly different for it to be an opposite authority that would avail the petitioners here. This position as it is my view that the MTN case did not change the position of the Apex Court in the case cited earlier, on the law that a party who tendered documents or documentary evidence in support of his case has a duty to link, to connect, and demonstrate the specific aspect of his case in respect of which the documents were tendered, if the court was to accord any probative value to them in evaluation of evidence. The case is therefore unhelpful to the petitioners on the point. I am conscious and aware of the submissions of the Land Senior Counsel for the petitioners that this court should hold that the first and third respondents have abandoned their pleadings because they did not call any witness to testify on their behalf. The tried position of the law is that a defendant to an action or a respondent in an election petition is entitled to rest his case on that of the claimant or petitioner, where he has, through cross-examination, elicited or extracted sufficient evidence to support and prove the facts or assertions contained in his pleading. In the circumstance, a defendant or a respondent to a petition can decide not to call any witness. That, however, does not amount or constitute not calling evidence or failure to call evidence. This is the position of the law restated by the Apex Court in case of Andrew and INF, decided last year by Kekere Ekun JSC. Our Lordship stated thus: with regard to the contention that the court below was wrong to affirm the finding of the tribunal that the first respondent did not abandon his pleadings by failure to call evidence in support thereof, I hold the considered view that both the lower courts were correct in their finding. Having tendered documents and evidence, albeit from the bar, and having thoroughly cross-examined and discredited the appellant, it could not be said that the first respondent had abandoned his pleadings. In Akomalafe and Guardian Price Limited, 2010, 3 NWLR, Part 1181, P338 at 351, F to H, and 353 to 354, H to B, this court held evidence elicited from a party or his witness under cross-examination, which goes to support the case of the party cross-examining, constitute evidence in support of the case or defense of the party. If at the end of the day, the party cross-examining does not call any witness, he can rely on the evidence elicited from cross-examination in establishing his case or defense. One may, however, say that the party called no witnesses in support of his case, but not evidence, as the evidence elicited from his opponent under cross-examination, which are in support of his case or defense, constitute his evidence in the case. The exception is that where the evidence so elicited under cross-examination must be on facts pleaded by the party concerned for it to be relevant to the determination of the question or issue in controversy between the parties, having regard with the fact that the relevant evidence elicited from the appellants relate to the facts pleaded by way of defense to the action, they form part of the respondent's case and can be relied upon by the respondent in establishing their case to the action without calling witnesses to further establish the said defense. End of quote. I also made reference to some other cases, citations of which are set out. I agree with the submissions of the Land Senior Counsel for the first and the third respondent to the effect that they have elicited sufficient evidence under cross-examination of the petitioner's witnesses in support of the first and third respondents' averment as contained in the pleadings in defense of the issue under consideration. The fact still remains that the petitioners, as I have found before, have not discharged the onus on them of establishing that the second respondent was not elected by a majority of lawful votes cast at the election. The evidence of all the 62 witnesses called by the petitioners is not sufficient to prove the monumental allegations of electoral malpractices pleaded in paragraph 16 to 106 of the petition. Pw.62, who is the star witness for the petitioner, admitted under cross-examination that he was not at any of the polling units, ward collation centers, local government collation centers, even state collation centers, to witness the voting, collation, and computation of the votes scored by the parties in the election. Pw.2 was in the petitioner's situation room in Abuja during voting exercise and announcement of results at the polling units and at all other stages of the election throughout election day and up to when election results were announced. He admitted that under cross-examination that collation and declaration of the presidential election were done manually in his presence in Abuja and was present when the chairman of the first respondent announced the presidential election, even though he did not sign the result. On the existence of INEC server, this witness stated that he has never seen it and he did not know its particulars. All he said is that INEC kept assuring them that electronic voting would take place, but its evidence under cross-examination, no such thing happened or took place. All the pieces of evidence given under cross-examination by Pw.62 were for the benefit of the respondent. I agree with the submission of the learned state to the respondent that the petitioners have not proved that the second respondent was not duly elected by a majority of lawful votes cast at the election. In the result, issue 3 is hereby resolved against the petitioners. Issues 4 and 5 were treated together. Now, after a consideration of the submissions by the Learned Senior Counsel for the parties, I resolved issues 4 and 5 as follows. The relevant paragraphs of the petition in respect of the allegation of corrupt practices can be found in paragraph 364 to 387 of the petition, while the portion pertaining to allegation of non-compliance with all the provisions of the Electoral Act as amended are also in the said paragraphs. The elements of corrupt practices given are as follows in the said paragraphs. A, compromise printing / production of election materials. B, manipulations / misuse of staff resources. C, manipulation of ballots and ballot boxes. D, manipulation of card readers. E, manipulation of accreditation and collation. F, manipulation of security agencies and militarization of election. G, manipulation of election material delivery. H, arbitrary arrest, detention of petitioners, members, and supporters. I, massive thumb printing of ballot papers. Particulars of non-compliance, which are set out in the paragraphs I mentioned, on issue of non-compliance with the provisions of the Electoral Act are as follows. 1, non-holding of election and cancellation of results. 2, wrong and deliberate entry of wrong results. 3, non-accreditation. 4, non-authentication of results by presiding officers. 5, overvoting. 6, inflation and deflation of votes. 7, wrong entries in Forms EC8As. All these were said to have affected the 11 forecast states of Borno, Yobe, Bauchi, Gombe, Jigawa, Kaduna, Kano, Katsina, Kebbi, Niger, and Zamfara states. First one to the provisions of Section 135(1) of the Evidence Act and the statute position of the law. The petitioners have a duty to prove all these allegations, which are of a criminal nature, beyond reasonable doubt, and by witnesses who can give an eye account of all the allegations because they are criminal in nature. In Emmanuel Umana, which I've started earlier, Nweze JCA said, in one word, the lower court, relying on the opinion in the newspaper article, purported to abrogate Section 135(1) of the Evidence Act 2011 by judicial fiat. That section provides that, and I quote, if the commission of a crime by a party to any proceedings is directly in issue in any proceedings, civil or criminal, it must be proved beyond reasonable doubt. In my humble view, it is difficult to see how the lower court could have legitimately wished away the position of this court, which, interpreting the above section, had maintained that a petitioner who makes allegation of a crime, of commission of a crime, as the basis of challenging the election of the candidate who was returned, must prove the allegation beyond reasonable doubt. See Buhari and Obasanjo, 2005 SCNJ 147, 2005-13 NWLR, Part 941-1, Nwobodo and Ono, 1984 1 SCNLR, page 1 at 28. Now, as pointed out above, the allegations of violence, voter intimidation, hijacking, and snatching of electoral materials, kidnapping, and others in paragraphs 27, 38, 39, 40, 41, 42, 43, 44, 45, 46, 47, 54, 61, Roman 1 to 4, 61, 10, Roman 10, 61, 11, 72, Roman 2, 26 to 43, 76, 78, 70, 78, 82, 83, 88, and particularly paragraph 15(1) of the first and the second respondent petition are criminal in nature and ought to be proved beyond reasonable doubt. I also refer to some other cases on the proof required, the standard of proof required in order to prove allegations of a criminal nature. The position of the law is thus settled that a petitioner who alleges non-compliance with the provision of the Electoral Act in the conduct of an election or in the electoral process, particularly in the polling units where election took place, the onerous duty of calling eyewitnesses, polling unit by polling unit, to give evidence of the non-compliance. It is also opposite to say that the position of the law today, as settled by this court and the Apex Court, is that where the allegation of non-compliance with the provisions of the Electoral Act and allegation of corrupt practices are made and coupled with allegations of commissions of crimes in electoral processes, eyewitness accounts must be called, and the allegations will have to be proved beyond reasonable doubt. How have the petitioners fared in the quest to overturn the election on the two allegations under issue 4 and 5? Now, under ground 2 of the petition dealing with non-compliance with the provision of the Electoral Act as amended, the petitioners pleaded in so many paragraphs of the petition that the agents of the petitioners were stationed at polling units in all the focal 11 states, and that they connived, that the respondents, officials of the first respondent, connived with the members of the security agents, namely members of the armed forces, in intimidating, chasing away supporters of the petitioners and members of the PDP, that this connived in stuffing ballot boxes with ballot papers, that they connived in assisting the members of the APC and supporters of the second respondent to carry out multiple voting, that the army and the police connived with the respondents to carry out massive rigging in stronghold of the petitioners, that the election was marred in Bauchi State by irregularities, violence, harassment, intimidation of the petitioners' agents by policemen and military men aided by the respondent, and there was unlawful cancellation of votes. They also alleged that no real voting or election took place in Dekina local government of Kogi State, as heavily armed thugs, fake policemen, sponsored by the third respondent, invaded several polling units. They also alleged that the Nigerian army were used by the respondents in Zamfara State to chase away PDP supporters, and that other criminal acts were committed by them. They also said that in Nasarawa State, out of the 1,496 polling units, the first respondent returned nil accreditation in 68 polling units. It is also the allegation that the second respondent manipulated and used security agencies to influence the outcome of the election in his favor by retaining General Atiku Yusuf Buratai, Chief of Army Staff, Admiral Ibok Ikwe Ibas, Chief of Naval Staff, and Air Marshal Sadiq Abubakar, Chief of Naval Staff, and Air Marshal Sadiq Abubakar, Chief of Air Staff, with a view to using them to intimidate supporters of the opposition to prevent them from voting. It is also the petitioner's allegation that in Rivers State, in Oyo State, in Kaduna State, notable members of the PDP were detained and arrested. It is their further allegation that in Rivers State, in Borno State, in Benue, Kogi, Yobe, Kebbi, Kaduna, Zamfara, Nasarawa, Plateau, and practically all the states of the Federation, military and police officers actively formed themselves as supporters of the respondent to attack, terrorize, and scare away the second petitioner's supporters and to prevent them from voting. The petitioners did not stop there. They also allege, by the state paragraphs under consideration under issue 4 and 5, that soldiers invaded several local governments in Rivers State to disrupt election. They also said that there was massive thumb printing of ballot papers by the agents of the second and third respondents in connivance with the first respondent. They also allege that prominent members of the PDP were detained in those 11 states which they consider focal states by security agencies at the instance and promptings of the second and third respondents. All the above inventory of criminal allegations, as pleaded and alleged by the petitioners in the pleading, are not established before this court, as none of the party agents or polling agents of the petitioners were called to prove the various allegations made against the respondents and members of the Nigerian Army and the police force. The only polling agents called are PW5 for Unit 008 Zamfara State, Nagogo Guram in Jigawa, PW6 for Unit 001, the Farm Duse in Gwaram in Jigawa State, 3, PW12, Unit 009, Tankokuba in Nasarawa State, 4, 5, PW46 at Unit 009, Sharp Corner, Karu in Nasarawa State, and PW49 for 001, Baroa Kwanga in Nasarawa State. All the other witnesses who gave evidence, that is PW14, 15, 39, 43, 48, 50, 51, 52, 56, 57, 58, and PW 13, 14, and 15 are all ward coalition agents from Niger, Nasarawa, Yobe, Borno, Kogi, who virtually testified of the information passed to them by the polling agents. Those who testified as local government coalition agents gave evidence as to what was reported to them or what the information they received from agents from their wards. Those who testified as state coalition agents in this petition for Niger, PW7, PW8 for Katsina, PW23 for Borno State, and PW61 from Kogi State. Though some of the ward coalition agents said they visited some of the polling units under them, where there were criminal complaints of violence and anomalies, but none of them said they covered all the polling units, and none of them stayed at any particular polling unit throughout the duration of the election. Apart from the 2 or 3 who said they did not vote, all the said witnesses voted and were duly accredited by their own accounts. However, apart from the 5 witnesses from the polling units, the other witnesses, as is shown, gave what is clearly hearsay evidence of what allegedly took place at the polling units. There are pieces of evidence either alone or taken together with any other piece of evidence, do not and are incapable of proving all the specific allegations of facts pleaded in grounds 2 and 3 of the petition, and all the criminal allegations contained in paragraph 227, 231, 232, 234, 236, 250, 293, 299, 302, 306, 308, and 309, 310, 317, 322, 328, 329, 333, 335, 373, 380, and 381 of the petition, which are not proved. Those witnesses are also not in a position to prove or establish any of the allegations under issues 4 and 5, they not being eyewitnesses, as alleged of the acts of violence or criminal acts and commissions of crime alleged as having taken place at the polling units. The polling units agents who could have testified to the horrendous allegations of crimes were not called. I made reference to some cases in respect of proof of allegations made in respect of polling units. And I continued that the petitioners did not call any of the persons detained or arrested by security agents as the alleged agents of the second and third respondent to give evidence of their arrest or detention or harassment, except that Buba Galadima, PW1, who gave the evidence that he was before and after the election harassed or invited by security agents. This evidence has nothing to do with all the allegations of violent criminal acts stated in the above paragraphs of the petition. All the paragraphs of the petition pleading allegations of misconduct by the army or the police are not established. There is no admissible evidence on record to support them. It is also noteworthy of what that none of the witnesses was shown from EC8As, EC8Bs, and EC8C to identify them in relation to the polling units, wards, local government, state, or centers they operated on the day of election. And no documents through them were tendered except from the bar, exhibits PW40, exhibit P40, and P62. It is also here pertinent to refer to paragraphs 277, 319, 326, 334, 336, 338, 349, 350, 352, and 358, 368, 369, 370, 371, 372, and 383 of the petition, which is falling under ground 2 and 3, and issues 4 and 4, issues 4 and 5, where certain individuals were accused of various electoral offenses, acts of thuggery, and compromise. Like I mentioned, there is no admissible evidence from any of the witnesses to link any or all of the individuals mentioned therein with the allegation of corrupt practices and non-compliance with the Electoral Act. The allegations against the said individuals were not established. Whatever evidence led, there is none that tantamounts, whatever evidence led is tantamount to hearsay evidence, as none of the witnesses actually witnessed any of the facts pleaded in the paragraphs of the petition. What is more, none of the personalities accused, including the security agencies, are parties to the proceeding, and this court will be acting in violation of the rights, as we have already decided in the ruling which I read earlier this morning, in contravention of Section 36(1) of the Constitution as amended, to adjudge them guilty of all the allegations against them in their absence. It must be stated that serious and criminal acts of electoral offenses and other criminal acts, irregularities, anomalies, rigging, etc., as laid out on the onset at the treatment of these issues, were made against the respondents and those perceived to be their agents on duty on the day of election. In the spectrum, like I mentioned before, of criminal law, allegations against agents cannot be held against their masters without any evidence directly linking the masters with the allegations against their agents. I'm not unmindful of the strong submission of the learned senior counsel for the petitioners, who stated that the evidence of PW62 actually proved and established grounds 2 and 3 of the petition, that in that their evidence was not challenged under cross-examination. In the petitioner's final address, in reply to the first respondent's final address, in paragraph 5.02, 0.03, 5.17, and 5.18 thereof, the learned senior counsel said thus, and I quoted him. Pt.3 is the collation agent of the petitioners in Kogi State. In Kogi State, he is one Captain Joe Agada, retired. Under cross-examination, he said that he voted in a polling unit at Olaboro Unit 18, that in some cases, disturbances started before election. He also visited 4 polling units on the day of election, and there are 2,300 polling units in his state. He visited only 4 polling units where violence, he said, was perpetrated. This was under cross-examination by the learned senior counsel for the first respondent. When he was further cross-examining, he said, he further said, among other things, that he was duly accredited before he voted, and that the card reader was used for his accreditation. He did not have the Form 40G. He did not have the Form 48 to evidence the recording of any violence. He did not sign, and he did not sign the form, and he refused to collect the result after the election. He did not have the voters register in respect of the places complained of about the complaints in respect of the state which he represented the petitioners. They have dealt with the evidence of PW60, whose evidence is also hearsay, in respect of the copies of the Forms EC8CAs, EC8Bs, and EC8C deployed in 11 states, in respect of which he was engaged to examine. The evidence of PW62, the star witnesses, once again, covers virtually all the facts pleaded in the petition. Under cross-examination by all the learned counsel for the respondent, he left no one in doubt that he had no personal knowledge of all that happened at the various polling units across the country, whereas the petitioners based their allegation in paragraphs 107 to 387 of the petition. I've mentioned it. He stated that he was at the situation room of the PDP on election day, and the information contained in his witness statement on oath about wrongdoings at polling units, ward levels, local government level, state level across Nigeria were gathered from third parties who were their agents in the said level of the collation of the election process. He was therefore not an eyewitness to any incident except the one that happened at the National Collation Center, where he was the national collation agent for the petitioners. He told the court that the collation was done all over the country, including the national level, manually. PW62's evidence cannot in the least at all command any value on the quantum of pieces of evidence given by him, and do not establish the horrendous allegations on commission of crimes and criminal allegations contained in the paragraphs of the petition. He cannot be in the situation room in his party's office and be at the polling units in all the polling stations or polling units and voting points in Nigeria. The petitioners under ground 2 of the petition, dealing with non-compliance with the provision of the Electoral Act as amended, pleaded in the paragraphs of the petition which I've mentioned that there was overvoting in so many polling units. For example, in paragraph 1153, the petitioners avert thus, and I quote, overvoting. The petitioners shall contend that out of 1,941 polling units in the affected 26 local government areas in the state, the first respondent in respect of the 490 polling units reflected results showing that the number of votes returned exceeds the number of accredited voters. The petitioners shall rely on this on the report of statistician. They also pleaded that many voters on the voter register in the 11 focus states were disenfranchised on various allegations of violence, manipulation, and compromise. The law is now settled that the only way to prove overvoting, inflation, or deflation of votes at the polling units, manipulation of voters' register by INEC officials, as pleaded by the petitioners, can only be proved and by a petitioner by tendering voters' register and the forms EC8As and all other relevant forms used in the election to enable the petitioners show that if the figures of scores representing overvoting is removed from the declared result, the petitioner would win the election. The petitioners in this case have not done so. They tendered no voters register. No. And the only forms they tendered from EC8As, ABs, EC8Cs, and EC8As were not utilized or demonstrated before this court by any of the 62 witnesses called by them. There is no doubt that this is detrimental to the petitioner's case. The petitioners have also made an allusion to the fact that the first and second respondent rested their defense on the evidence given by the petitioners and submitted that they are deemed to have abandoned their pleadings and admitted the petitioner's case. I have dealt with this issue in the course of this judgment and found that it cannot be said that the first and second respondent abandoned, the first and third respondent abandoned their pleadings or that they have conceded to the petitioner's case. No facts and evidence on record has shown that the petitioners have discharged the initial burden of proof cast on them by law under Section 131 to 136 of the Evidence Act 2011 and the Electoral Act and regulations and guidelines made thereunder in respect of any of the grounds upon which the petition is premised. It is true, as borne out by the record, that the evidence elicited under cross-examination of the petitioner's witnesses by the first and third respondent established their defense to the petition. The evidence elicited on facts and issues joined on the petition and replies of the parties go to support the pleadings in their defense. It is also pertinent to deal with the submissions of the respondent that the petitioners merely dumped the documents tendered before the court on these particular issues without relating them to any aspect of their case, and as such the court cannot deem them to approve their case. The court cannot help the petitioners to do their job. The learned senior counsel to the petitioners argued to the contrary and contended that having tendered the documents from the bar, they become evidence. I have long dealt with this, and the law is now firmly settled that when documents are tendered from the bar or by a person who is not the maker, the court cannot accord such documents any probative value unless the makers are called to testify on the documents and answer questions in cross-examination on them. This is the position of the law. The respondents are therefore right in their submission that the petitioners dumped all the forms EC8C series and other documents on this court. None of them was utilized by any of the witnesses who testified on behalf of the petitioners in order to demonstrate the specific areas, particularly that relate to issue 4 and 5 in paragraph 107 to 387. All the aspects, like I said in the earlier portion of this judgment, which were not demonstrated or linked to specific areas that relate to issues 4 and 5 of this petition, remain dormant and of no probative value to the petitioners. In the final result, for reasons set out in this judgment, I have come to the conclusion, which is inevitable and unavoidable, that the petitioners, on the basis of the evidence adduced before this court, have not proved any of the grounds contained in paragraph 15 of the petition as required by law. Failure by the petitioners to satisfactorily discharge the burden or onus of proof placed on them by law, this petition is liable to be and is hereby dismissed in its entirety. Before I end this judgment, let me also place it on record, and I would like to commend the Learned Senior Counsel for the parties for their industry and the brilliant final addresses on the issues conversed in this petition, which were very helpful to the court in the determination of this petition. We appreciate the cooperation of all the Learned Senior Counsel and other counsel who appeared before us in this petition throughout the conduct of the proceedings before the court. Parties in the petition shall bear their respective cost of prosecuting this petition. My learned brother to my immediate right will pronounce his decision in respect of this petition.
I took part in the conference linked to the judgment. I agree entirely with what has just been read.
My learned brother to my immediate left will pronounce his decision in respect of this petition.
I agree with the robust judgment pronounced by my learned brother, Muhammad Lawa Garba, JCA, with the addition of these few words by way of emphasis. Paragraph 15D and E of the petition averred that, I quote, D, the second respondent was at the time of the election not qualified to contest the said election. E, the second respondent submitted to the first respondent an affidavit containing false information of a fundamental nature in aid of his qualification for the said election, end quote. Section 138, subsection 1A and E of the Electoral Act 2010, as amended by the Electoral Amendment Act number 25 of 2015, states thus, I quote, an election may be questioned on any of the following grounds. That is to say, A, that the person whose election is questioned was, at the time of the election, not qualified to contest the election. E, that the person whose election is questioned had submitted to the Commission affidavit containing false information of a fundamental nature in aid of his qualification for the election, end quote. The RW2, Mr. Suleiman Issa Mayadua, who was 77 years old at the time of his testimony on 30th of July 2019, swore that he was one of the classmates of the second respondent at the Katsina Provincial Secondary School, now Government College Katsina, between 1956 and 1961, where English language was the medium of communication, and that they wrote their examination in 1961 upon reaching class 6 in the same secondary school. The evidence of the RW2 was not discredited under cross-examination. A witness of 77 years old, such as RW2, is indeed an old man who, in virtue of advanced age, will lay on the side of truth. See in Wawuba against Enemo, 1988, 2N WR Part 78, page 581 at 595, where the Supreme Court heard per the judgment prepared by Nameka Agu, JSC, as he was now of blessed memory thus, I quote, it is a matter of common knowledge that old men often find it difficult to trace the truth, end quote. Accordingly, I accept the uncontradicted evidence of RW2 to the effect that the second respondent was indeed one of his classmates at Katsina Provincial Secondary School, now Government College Katsina, between 1956 and 1961, where they sat for their final examination upon completion of Class 6. Educational qualification for election to the office of President of Nigeria is stated in Section 131, subsection D of the 1999 Constitution as altered. Thus, I quote, "A person shall be qualified for election to the office of President if D, he has been educated up to at least school certificate level or is equivalent," end quote. The educational threshold of, quote, school certificate or is equivalent, end quote, in Section 131D of the 1999 Constitution as altered is interpreted in Section 318 sub 1A and B thereof in these ways, I quote, "School certificate or is equivalent means inter alia at least A secondary school certificate or is equivalent, or grade 2 teacher certificate, or guest certificate, or B, education up to secondary school certificate level," end quote. The court, that is this court, the Court of Appeal, Koram, Obadina, Sanusi, Ogboagu, JJCA, had cause to interpret a similar provision in Section 106 of the 1999 Constitution, relying on Section 318, 1A and B thereof in the case of Digai and another against Nanchang and others. Citations supplied per Obadina, JCA, thus, I quote, "What is required under the law is that there must be evidence that a candidate is educated up to the school certificate level, and not that he must produce a certificate to that effect," end quote. There's also the case of Bayo against Injida, citation supplied, where it was heard by Ogboagu JCA, thus, as I quote, "As regards a secondary school certificate level, one does not have to pass the secondary school certificate examination. It is enough, in my view, that one attended a secondary school and read up to the secondary school certificate level, that is, without passing and obtaining the certificate," end quote. There is again the case of Chukwu against Chionwo, citation supply, where his lordship occurs, JCA, now JSC, while interpreting Section 99 of 1 of the local government, bracket, basic constitutional and traditional provisions, and bracket, decree number 36 of 1998, which is similar to Section 318 of the 1999 Constitution supra. On the phrase, quote, "school certificate or its equivalent," end quote, here thus, I quote, "It is not absolutely necessary that such a person must possess a certificate to enable him function effectively," end quote. Generally, there is a rebuttable presumption of literacy. A person is presumed literate until the contrary is proved by the person doubting or challenging that person's literacy. See the cases of Anaiza against Anyaso, then Otituju against Governor of Ondo State, then Jubosu against Obadina, then Ezeego against Awudu, then Sunday against FRN, all citations applied. No scintilla of evidence was brought by the petitioner to rebut the presumption of literacy in favor of the second respondent that he attended education at least up to secondary school level in 1961 as stated on oath by the RW2. The second respondent therefore possessed the minimum educational qualification under Section 131D of the 1999 Constitution, read with Section 318 sub 1B thereof, to contest the said presidential election. The information given on oath by the second respondent to the first respondent, that is INEC, is P1 form CF001 on his educational qualification reads, quote, "Schools attended / educational qualification with dates. Attach evidence of all educational qualifications." Yes, and that's my one school primary qualification, primary school certificate, year 1952, 2 secondary, that is WASC 1961, then 3 higher, officer cadet 1963. The affidavit accompanying the information is P1 Form CF001 on educational qualification sworn to by the second respondent reads, I quote, that I am, number one, that I am the above-named person and deponent on this affidavit herein. 2, that all my academic qualifications as filled in my presidential form, present APC/001/2015, are currently with the Secretary Military Board as at the time of this affidavit. 3, this affidavit is made in good faith and for record purpose, end quote. The information given by the second respondent to the first respondent in Exhibit P1 from CF001 was on the submission of his primary school and secondary school certificates to the military at the time of his enlistment in the Nigerian Army in 1963. Giving false information and affidavit that amounts to lying on oath, it is a criminal offense under Section 156 of the Penal Code, which provides thus, I quote, whoever being legally bound by an oath or by any express provision of law to state the truth, or being bound by law to make a declaration upon any subject, makes any statement verbally or otherwise which is false in a material particular and which he either knows or believes to be false or does not believe to be true, is said to give false evidence, end quote. The next stage is on the proof or the allegation that the information by the second respondent to INEC in P1 from CF001 on educational certificates is false. This is a criminal allegation which is directly an issue in the election petition, which must be proved beyond reasonable doubt or with lesser-like precision by the petitioners who had asserted in the petition that the information on the educational qualification of the second respondent given on oath by the second respondent to the first respondent is P1, that is from CF001, is false, with the Section 135 of the Evidence Act 2011, that evidence which provides thus is part of the judgment taken as read. See also the cases of Mohammed against Wamako and others, citations applied, Ipiaz against OT, citations applied, Saleh against Abba, citations applied, Mehaja against Gaidam, citations applied. It is tried that he who asserts has the burden to prove the assertion or allegation. And if the allegation or assertion is criminal in nature, it must be proved beyond reasonable doubt by the person asserting it. See the case of Zakala against Edosa and another, citations applied, pre-release judgment prepared by his lordship, Echo JSC, to the effect that proof beyond reasonable doubt is not established by mere assertion. Furthermore, the Supreme Court, while considering similar issue inter alia of false declaration in the case of Mehaja against Gaidam, citations applied, heard the lead judgment prepared by his lordship, Bagay, JSC, now His Royal Highness, the Emir of Lafayette, inter alia, that I quote, the necessary question is what must a party prove to succeed on the allegation of false declaration? The nature of evidence required in this kind of situation is similar to that of mathematical precision, or 2 multiplied by 2 equals 4. 2 times 2 is equal to 4, end quote. See also the guy against Nanchang Supra at 64, where the court held that, I quote, as I had indicated earlier in this judgment, this issue revolves on the 2 other issues already treated by me, but in specific hinges on the complaint of an alleged giving false information to the third respondent by the first respondent. Firstly, giving of false information either to the police and in this instant case to the third respondent certainly amounts to an allegation of committal of a crime. Again, the standard of proof is beyond reasonable doubt. See Section 138 of 1 of the Evidence Act, end quote. The quantum of proof beyond reasonable doubt will therefore be proved with mathematical precision, as stated by the Supreme Court in Mehaja against Gaidam, Supra. The petitioner sought to prove the allegation of false information by relying on Exhibit P24, a copy of the Vanguard newspaper of 21st of January 2015, where it was reported in part that the late judgment captured it, so I will not repeat it. It is my judgment too.